both powerful and profound, and unfolds in three critical acts. First, we are the architects of justice. It falls to us to draft and pass laws that not only create independent oversight bodies, but arm them with the legal authority, guaranteed access, and robust power they need to be effective. Simply put, we do not merely enable oversight, but we legislate its teeth. Second, we are the unyielding scrutineers. Our committee rooms must become the engine rooms of accountability. As Churchill has said, that Parliament is a workshop of democracy, and that democracy is a barometer of public opinion. It is here that we must wield our parliamentary power to summon ministers, demand evidence, and dissect prison budgets. This requires us to be relentless in our inquiry, using both the cold data of official reports and the vital ground truth testimony from civil society to ask the difficult questions that others would rather ignore. Third and most fundamentally, we are the voice of the voiceless. In Parliament, we represent every constituent, and that duty does not stop at the prison gate. Those held in the state's custody are, by definition, rendered silent and invisible. Therefore, it is our solemn democratic duty to see the unseen, to speak for those who cannot speak for themselves, and to ensure that their humanity is never forgotten in the corridors of power. And as Nelson Mandela has said, that one of the yardsticks to judge the society is how they treat their incarcerated population. I paraphrase his words. But to perform this role effectively, we ourselves need capacity building. We cannot oversee what we do not understand. We require dedicated training on international human rights standards, analyzing prison budgets, recognizing signs of torture and ill treatment, and on the principles of rehabilitative justice. We must invest in our own ability to be effective overseers. This leads me to the final critical pillar, which is the engine of continuous research. We cannot be guided by ideology or outdated practices. Our policies must be fueled by evidence. We must champion and fund independent research into what works in rehabilitation, in reducing violence, and in successful reintegration. What is the best practice in electronic monitoring, in education programs, in mental health? We need to ask ourselves these difficult questions. We need a living repository of knowledge, continuously updated to inform our laws and our oversight. As the saying goes, what gets measured gets managed. We must measure the right things, not just the number of inmates, but the rates of recidivism, the level of violence, the success of rehabilitation programs. As I conclude, Madam SG, dear colleagues, distinguished ladies and gentlemen, I must reiterate that the task before us is to build an oversight architecture that is not just compliant with the law, but inspired by a commitment to human dignity. This is not a peripheral issue. The quality of justice delivered within our prisons defines the quality of justice in our society as a whole. We must therefore collectively reaffirm our commitment to building and sustaining this collaborative framework. Only this can bridge the gaps and ensure that our oversight is equal to the values we profess. I thank you. Merci beaucoup. Muito obrigado.
Thank you very much, Honorable Speaker. Before you take leave, let me thank you on behalf of the SADC Parliamentary Forum and SADC citizens who are really joining us online and who would continue to listen to your unfiltered thoughts around oversight, around human rights and dignity, your arguments around state operations, around evidence being central to oversight and ensuring that the golden triangle of reform is not compromised are really welcome. Honorable Speaker, your emphasis around early warning systems is critical. and will surely find its way into the model law. Similarly, you speak of unyielding scrutiny, something that the model law is making efforts to ensure that the tools are availed, the necessary structures are availed, the necessary alignment with other government machinery is put in place. And indeed, it is only when Parliament can become a real workshop of democracy, where we safeguard, where we train and analyze matters and use evidence in terms of taking advantage of the mandated roles of Parliament. Honorable Speaker, I thank you for your kind guidance and for your unfiltered thoughts and arguments that you put forward in terms of the price of human dignity overall, which will indeed ensure that oversight has teeth. Thank you, Honorable Speaker. Wish you a fruitful afternoon.
Thank you so very much. Let me, Madam SG, apologize that we are currently in a seminar for the National Development Plan number 12. I am a co-host with the National Planning Commission, and so we are busy on the seminar and in preparation for a special meeting of Parliament, which has begun yesterday but will continue on Thursday. So I wish I could be with you the whole day and benefit from discussions of this forum. But unfortunately, I will have to be and play the co-host role. And I wish you fruitful discussions and a great day. Thank you so very much.
Thank you, Honorable Speaker. We thank you for, yielding for us in this regard. Wish you all the best with NDP 12. All right, at this point, I would like to invite our legal drafter, Ms. Annika Mirkote. I don't know why this tongue ties me, Annika, all the time. To kindly take the floor and make the presentation. And as we move along, weave in some of the thoughts that the Honorable Speaker has put through somewhat towards the end. Thank you. Annika?
Thank you, Honorable Secretary General, and all protocols observed. I was almost brought to tears by the beautiful presentation of the speaker, because it's encouraging to see such a depth of understanding around prison oversight and around the need for us to ensure that prison oversight is meaningful and leads to lasting change. So I've taken quite detailed notes on the speaker's recommendations on some of the things we can add to the model law to actually ensure that it has the impact that we want it to have. I'm just going to take us very quickly through the draft outline of the model law for people to see what we intend to cover in it, and then that would hopefully encourage discussion on additional issues we need to consider or amplify. So the main thing about the model law is really setting out a core set of principles around accountability. And the Speaker of Botswana mentioned this already about transparency, upholding human rights, accountability, the independence of oversight mechanisms, empowerment of prisoners, and procedural fairness. And he was very good at noting the importance of data and mandatory reporting, and how we actually ensure that there's specific mechanisms in place to so that there's coordination and complementarity between different oversight mechanisms. So within the model law, there is a section dealing specifically with complaints management. And the reason for that is that one part of oversight is to ensure that complaints of persons in prisons are addressed properly and promptly and with care. And it is incumbent on oversight mechanisms to really ensure that these complaint mechanisms work properly. And we have to understand that there are both internal and external oversight measures. So how complaints are managed are part of how there's a form of internal oversight for prisoners to ensure that their rights are respected and protected. And in addition, there ought to also be, from a departmental level, internal inspections to ensure that there's compliance management and compliance with domestic laws and international and regional human rights standards. So the model law the draft goes a bit into that and into how such complaints ought to be managed, including ensuring that that everyone who complains or requests something within the prison are treated fairly and equally and without bias, and that they are aware and able to access complaints mechanisms. We know that not every person in prison are on the same footing and have the same power and ability to make complaints. And it's really about how do we support everyone to be able to raise their issues and request support where they need it. Importantly, and this is part of what the speaker mentioned around ensuring effectiveness of measures and also dealing with the opacity and culture of secrecy and bureaucracy within prisons. And what one needs to ensure is that any sort of complaints are followed through with an effective remedy, including, where necessary, criminal proceedings where officials themselves have been accused of torture or other criminal acts. And this is very important because there is this culture of impunity that's very much tied to the culture of secrecy within our prison systems. And that is why it's very important to ensure that there are no reprisals against complainants and that there are processes in place for whistleblowers to be able to expose some of the discrepancies that exist within the prison system. So there are within the model law overview of the various oversight mechanisms that already exist in most of our countries within the SADC. And the reason why it speaks to all the oversight mechanisms is because that there's an understanding that we need each oversight mechanism to work collaboratively together. Each oversight mechanism will look at different issues, and we need to ensure that all those oversight mechanisms work. We cannot just rely on one oversight mechanism, because if that then fails, then we would have serious problems around oversight and monitoring of conditions in detention. So the first oversight mechanism, which exists in all SADC laws, are about official visitors. And the key question there is really about the extent to which visitors are able to access prisons. And the speaker specifically raised the issue of civil society participation in oversight. But civil society organizations are not always recognized as official visitors. And we're not saying they should be able to show up at a prison unannounced. But there could be procedures put in place where prison organizations who provide services to prisoners, such as legal aid, paralegal services, mental health support, that they actually are designated as official visitors, obviously with some sort of memorandum of understanding, but to ensure that there is that space for independent civil society to, like the speaker said, be the eyes and ears of persons in detention. And I think this is very critical because in many countries it is actually impossible for civil society to access prisons at all. The other part of oversight is visiting justices, and this is a practice that's existed for centuries, where judges have the duty to visit places of detention. However, these duties are very rarely included in legislation, and it's more a practice than a a legal requirement. And the idea with the model law would actually be to encourage governments to make these visiting of prisons by the judiciary a legal requirement, so that the law can then guide them on what exactly they might look at when they go to prisons and what they do afterwards. And here again, it's important, for example, for visiting justices to ensure that complaints mechanisms work, to identify if there are illegal detentions or where people have exceeded the length of time they ought to be in detention legally, and also to look at whether mandatory reporting is complied with. So, for example, we know that deaths occur in prison, but often these are not recorded, and we do not know often whether they are natural or unnatural deaths, and where they were unnatural, what the cause of that had been. So, and this is something very basic that is mandatory in all our prisons to record, but that actually has huge gaps, and it requires external oversight to ensure that these documentations are kept properly and updated regularly. The same with looking at how early release works, what the processes are for rehabilitation, and the extent to which other important factors are considered. The other human rights mechanism, or the other prison oversight mechanism, is national human rights institutions. Again, in all SADC countries, national human rights institutions have the mandate to visit places of detention. These would include national human rights commissions and ombuds, and they have that same duty in all places, in all countries. In many countries, however, the laws relating to these, the Ombud or the National Human Rights Commission, can potentially be strengthened to ensure that they feed regular information through to Parliament to assist parliamentary oversight when it comes to prisons. A key concern has been that although national human rights institutions are mandated to visit places of detention, they do not always have the funding to do that regularly, and they are not held to account when they haven't visited places of detention for a long period of time. So these are important issues that is also subject to parliamentary oversight, where parliaments, when NHRIs report annually, where parliaments should engage them on how often they have actually visited places of detention and dealt with complaints by prisoners relating to conditions in detention. In many of our countries, there are also independent correctional center visiting committees, and the model law deals a bit with that because there have been some gaps in how these committees work, where they do work, especially around how one will ensure that if there are lay visitors who are linked either to the department or independent prison oversight mechanism, that these visitors who are often within the area in which the prison is located, that they receive adequate training and guidelines on what is expected from them and how they should report to the oversight bodies on their findings when they visit places of detention. And then there are designated independent correctional center oversight bodies. These exist in very few countries in SADC. Your best practice is probably Malawi, which has included for this oversight body in its constitution itself. And ideally, this would be what we work towards, that eventually all countries would have a body whose sole function is to provide oversight to prisons. We might not have this immediately, and there could be budgetary constraints and all of those things, but it is included within the model law. And the idea would be that countries would pick and choose which sections of the model law they can comply with immediately in terms of reforming its laws, or where they want to investigate what sort of mechanisms they could start implementing in their countries. I'll skip through some of the other stuff, but just to note that health professionals do access places of detention. Either they are employed within the prison facility, or they visit prisons, or prisoners come to them where they are based in hospitals. So linked to health professionals, there are certain mandatory reporting requirements that could actually assist in oversight of prisons. And then there are certain groups that have specific requirements when it comes to oversight bodies interacting with them, and the questions that oversight bodies ought to ask to ensure that their rights are dealt with properly. The important thing that was raised by the Honourable Speaker was around the issue of data and the need for us to specifically include research within the model law to ensure that parliaments have the evidence that they need to develop policies in relation to prisons. And I think that this is very important. And one way in which to strengthen this would be to ensure that there is mandatory reporting, and to also ensure that there is sufficient training and that correctional services staff themselves are trained on how to gather data, and what data needs to be collected that can then be sent to oversight mechanisms to monitor. So around mandatory reporting, the legislation ought to really define what is required to be reported and what format. And there ought to then be, in addition to incident-based reporting, also other data collected that would assist in policy development and adequate budgeting by Parliament. And it's then up to the oversight mechanisms when they visit, to ask for this data and to ensure that the data requirements are properly complied with. And within that, there is certain types of data that is very critical to ensure that any further abuses are prohibited. So this would include, for example, immediate reporting of custodial deaths, serious injuries, or acts of torture, and to an independent authority specifically who can investigate such cases impartially. It's also important to disaggregate data so that one know exactly who are most at risk, which prisons are most involved in certain types of abuses, and so that one can actually have targeted interventions where needed to address issues of pretrial detention or sexual violence or torture or other sort of problems within the prison system. And what's critical really is that this data be reported to Parliament, and developing those mechanisms that are necessary to enable Parliament to receive the data on a regular basis. And finally, the model law will speak a bit about parliamentary oversight itself and how parliaments can actually ensure that the various prison oversight mechanisms do their work, are supported to do their work, and that their work and their reports are properly considered and interrogated before Parliament by members of Parliament. So I'll leave it at that. Happy to take any questions.
Thank you very much, Anneke. And thank you for bringing out that correlation around what the model law will envisage to do, and also how input or these consultations will ensure that we go further into this particular mandate. The Honourable Speaker is back on. I'm sure you also feel, Honourable Speaker, if you have any more questions in this regard. And colleagues online, may I kindly invite you to make inputs. Indeed, I see Mr. Roderick Zalimba. Kindly introduce yourself, the organization you represent, or in your individual capacity, how you fold into the process.
Thank you very much, Madam Chair. My name is Roderick Zalimba, and I am the Executive Director of Prison Fellowship Malawi. We are a faith-based non-governmental organization working in Malawi, and we collaborate with the prisons. Thank you very much for the elaborate presentations. I think I have a question and just a point of emphasis. To begin with, I wanted to reflect on the sentiments made by the speaker, who was the first speaker on this forum. I think he did allude to the need for us to have instruments that help us to break the cycle of crime. And I find this to be very, very pertinent in our efforts for oversight, because in as much as we are working to ensure that we create oversight systems, I think it is also very, very important that we ensure that we have systems in place that ensure rehabilitation and reintegration. I am an ardent supporter of the concept of rehabilitation and reintegration, and therefore I would want to see within this proposed legislation that there is emphasis on the notion of rehabilitation and reintegration, because the success of a system could be gauged or judged on the basis of how much it is able to rehabilitate, how much it is able to reform, how much it is able to reintegrate people who are passing through the system. And secondly, I wanted to also just weigh in on the issue of the mandatory reporting. I wanted to add to the list of the data that is being proposed for possible collection, or the issue of recidivism rates as a possible point that maybe we may need to consider, because that's usually an issue. We've been with various systems. You ask questions around how many inmates have gone in and how many inmates have gone back. Usually such data is not available, and yet it is very critical. It would inform policy direction. It would also inform how successful the system is. So perhaps it's worth considering that we may add that recidivism rates, how much the system is able to recycle, or how much the system is successful, how many people successfully stay in society and they do not return to prison. Thank you very much.
Thank you so much, Mr. Zalimba, for your input. I'm sure this is one area where our consultant will better engage with you, because these are the issues that they have also put forward for consideration and input. Is there any other hand online? You seem to be the only one who's asking the question now. Perhaps I'll hand over to Anneke to just elaborate a little bit more and maybe share your thoughts of the ambitions that could be there, the tools that have been cited, and how this can actually be integrated in the model law itself or as a tool for oversight. Thank you.
Thank you so much. And thank you, Mr. Zalimba. I think this is really a critical issue. Just on the, I think definitely there ought to be increased emphasis on rehabilitation and reintegration within the model law, and that it's important for oversight bodies to look specifically at that. Now, at the moment, the oversight bodies do not really look at that. Specifically, if you look, for example, at human rights institutions or visiting justices who visit prison, that is not necessarily the area of training for them to adequately assess whether rehabilitation and reintegration processes are sufficiently in place and sufficiently managed. So I think that brings us to the point in the model law really about training of oversight mechanisms, and how do we ensure that oversight, that those people who visit places of detention have the necessary training to ask the right questions. So you don't really just, sorry, I'm coughing this morning. You don't really want them to just go to the prison and say, do you offer skills training? You want to really assess what sort of skills training, are they able to use that skills training upon their release? Is it something that's meaningful for them? We know, for example, that even within skills training, not all categories of prisoners benefit in the same way. So women often don't benefit from rehabilitation and training in the same way that men do, or foreign nationals might not benefit. So I think there's probably a need for a section that specifically looks at that. And then I would completely agree with the issue of recidivism rates. And I like how you look at recidivism rates, not just in respect of how we judge the people who get into the system, but in respect of how we actually judge the system. And looking at recidivism rates as a sign of failure of the system, as opposed to failure of the individuals. And I think that is a very encouraging and positive way in which to look at things, which then raises a lot of other questions. There might be some question around, this is not my area of expertise, around how one would adequately collect recidivism data and whether the correct systems are in place between different prison facilities and within the criminal justice system itself to collect that data in an adequate and efficient way. And obviously, there are other more nuanced issues around recidivism rates and how one cannot count everything as recidivism if it's sort of different offenses and all those sort of things, but how one actually use the data to assess the quality of the detention, and perhaps even then include within oversight asking persons who have reoffended what ought to have been in place in their first periods of incarceration and post their release to support them to not reoffend. And yesterday, when we had consultations with the youth, they specifically emphasized issues like labor integration, which is very hard for persons with a criminal record, and even support groups and other type of psychosocial support post-release to recognize the difficulties people face in reintegration itself, which might then lead to reoffending. So I think these are all very critical issues. I think it would be useful perhaps to also, if people have opinions linked to what the Honourable Speaker had mentioned about civil society participation in prison oversight, if there are any ways in which one would want to amplify that, because I note, for example, Mr. Zalimba, the issue, your own organization, which is more faith-based organization accessing prisons, do you think organizations like that have a particular oversight role to play? And how would they feed any information that they obtain into improving the system? Is it through communication with the head of the facility or through referral of cases to external oversight mechanisms, or how can one build something in where there's actually a link between civil society and the official oversight mechanisms? I'll leave it at that.
Thank you very much. And again, thank you so much for asking that question, Mr. Zalimba. It's important because I think for anybody else engaging in this discourse for the development of the SADC model law, issues of proportionality in relation to the type of crimes that are committed, even by gender, becomes very critical, particularly if we're going to be looking at issues around sexual violence, and also just women and children, as it has been coming through in the consultations. And others has been asking, are you saying we should let people who have committed crime just get away with it? And, you know, we need to study the patterns. how many of those in a particular category get rearrested, and after what period, and what type of crime, what do you call them? Categories. I don't know if it's called categories. Crime categories are we referring to? I think, is it violent crimes? Is it sexual offenses? Is it drugs, crimes? And, we shouldn't just be throwing around words to say it's these type of people because they come from, this type of background among others. So I think I like what you've discussed, and also just to look at the length of sentences that go with that. I mean, there are a lot of concerns around psychosocial support that needs to be rendered. There are systems and also other recommendations that the model law is putting forward. And I think it would be good for you to mobilize support in upcoming consultations with your constituents and others so that we really get the emphasis from your end in terms of how the model law can eventually be tailored to take this into account. So don't give up. The reason for consultations is to hear what the constituents who have much more experience in this area have. The consultant has everybody talking to her. And if there is no cogent propositions that are being made in this regard with proper data, it may not find its way in a manner that satisfies your offenders or satisfies yourselves and among others. I don't know if I'm making sense, but I'm trying to, it's not my area, but having listened to the consultant and read her position paper among others, one begins to see the value in really collecting data around the percentage of recidivism, on those areas. So thank you so much for that question, and we've taken note. Any other questions, colleagues online? Okay, I guess it was clear or it was technical. It's one of the two. So we are inviting you to further consultations, and let me just share with you, let me just share with you and those who are listening online where we are at in this process, just to indicate that indeed this consultation is meant to really ensure that we get as much data. There's always new information coming up. We don't want to lose that. And just to say that the SADC Parliamentary Forum has a Bill of Rights that they have developed over time. We have the model law on HIV and AIDS, we have the model law on elections, the model law on public financial management, the model law on eradicating child marriages and protecting children already in marriage. We also have a model law on gender-based violence. We also have minimum standards for the protection of vulnerable populations, including prisoners, insofar as HIV/AIDS transmission is concerned. So how we proceed in this manner is that we have had or we've gone through what we refer to as the initiation stage, where concept notes were drawn, data was collected, and committees were approached to look at this matter. It went to the plenary assembly through a resolution, and the plenary assembly through parliaments and other stakeholders said we do need to go ahead and develop this model law. Then there was research stage, which was hidden in there, where the consultants started doing the position papers, and they continue to do the position paper in view of the sensitivity of the issues and the changing nature of the context. Where we are in between research, consultation, we are also at the drafting stage of the model law. And we are yet to, this is a very, tedious process, which makes consultants where they think they're done, having to go back into the process, collecting new data, listening to the input that's coming out and seeing how they can refine the model law. We are yet to go to the approval stage where we're going to review what the consultations brought to the table, what the consultants were able to formulate, and then the formal adoption by the joint committees of the SADC member parliaments, and then the plenary assembly where the model law itself will be adopted. This is the easiest part. The serious part becomes the domestication stage, where after those proposals have been made through the model law, whether the uptake of countries will be significant, whether what you are speaking to from Malawi will find its way into national laws, and whether or not activism continues. The speaker spoke about civil society organizations, lobbying. We need civil society. We cannot do without civil society. And they must be integrated across all structures for oversight. And therefore, the domestication component will become critical. Otherwise, this investment will not make sense. I've talked about the approval stage. I'm not going to go deeper, but this is, so who are we consulting? The engagement cuts across. Some are not here, like academia, research institutions, and others. We invite you, if you, for instance, write to the consultant and said, I would like to make a consultation with like-minded organizations, we will accommodate you where you can talk about a particular issue that can be refined for drafting. But we continue to consult parliaments, who are the key drivers of legislative reform and oversight. The justice system was consulted and continues to be consulted. Prison authorities, prison management and correctional officers, human rights bodies, former prisoners, the list goes on. This is just to say you can add more to this list if you think that we are missing out on other consultations. Now, we have a calendar for these consultations. If you go to our website, you'll find that the calendar continues up to the end of the month. October was put aside for consultation, like I said, drafting, consulting, going back in this process. So we've already done several consultations. I think by now we're at the 7th consultation. Today alone, we have 2 consultations. There's one in the afternoon. So if you feel you want to attend, we have Amnesty International also coming in to give context to some of these things. Those who are joining, you are welcome this afternoon, because you may then begin to have reflected, invited more colleagues to come and help with a particular issue. 16, 17, 20th, we continue with the consultation up to the 21st. So as I conclude, I'd like to thank the consultant and thank the honorable speaker, thank participants who have joined us online in this regard, and I invite you to continue to invite others who may give value to these consultations. And I'd like to quote, it is of utmost importance that prison reform is not regarded in isolation from broader criminal justice reforms. Effective prison reform is dependent on the improvement and rationalization of criminal justice policies, including crime prevention, sentencing policies, and on the care and treatment made available to vulnerable groups in the community. Reform of the prison system should therefore always take into account the needs relating to the reform of the criminal justice system as a whole and employ an integrated multidisciplinary strategy to achieve sustainable impact. Thus, reform initiatives will usually need to also encompass criminal justice institutions other than the prison service, such as the judiciary, prosecution, police services as relevant. This is UNGC in 2011 in one of their position paper. Thank you for being change agents. We invite you to continuously participate in these processes. And we'll also, if you want, kindly get in touch with us, prisons@sarecpf.org. You can ask us a question, request for information. You can alert us to groups that we may have to really engage with, and we can find formalities and in this regard to ensure that we do so. Thank you very much. If there are no further questions, thank you very much, Anike, and the honorable speaker. Admin, you may now terminate.